Hi folks, welcome to SQE1 window, and in our chapter 4 of criminal litigation, we talk about prosecuting summary offences and either way offences. So before we dig into it, let's map out everything. Let's talk what we will discuss in this session. So we are dealing with two distinct procedural tracks that diverge based on offense classification. First is summary only offenses, and they are prosecuted exclusively in the magistrate's court. The procedure is streamlined, efficient, and relatively straightforward. There is no possibility of transfer to the Crown Court for trial. So either way offenses follow a more complex path. So these offences can be tried in either magistrate or Crown Court. So there is a venue decision process involving both the court and the defendant. So this creates strategic choices that counsel must navigate carefully. So key checkpoints apply to both tracks: charging, disclosure, entry at a plea, trial, management, and directions. Understanding these checkpoints helps you track where a case is in its journey through the system. For either way offences, especially, the strategic choice between magistrate's court and Crown Court trial becomes critical. So this choice affects everything from trial preparation to potential sentencing outcomes. So for exam focus for this chapter is straightforward. The question can be, what route does this offense follow? Classification determines procedure, so always begin by identifying whether you are dealing with summary only offenses or either way offenses. So summary offenses, let's start with summary offenses. First, these are the least serious criminal offenses in the hierarchy. So we are talking about common assault, driving without insurance, minor public order offenses, and low value criminal damage. So second, they can only be tried in magistrate court. The Crown Court has no jurisdiction over summary only matters. So there is no possibility of jury trial. Third, the procedure is streamlined for efficiency. Summary cases move through the system more quickly than either way or indictable offences. Fourth, there is no mechanism for transferring summary trials to Crown Court. The magistrates handle everything from first appearance through the verdict and sentence. Fifth, sentencing powers remain with the magistrate. The maximum sentence is limited by the magistrate statutory power, typically 6 months for a single offence, occasionally more for specific offences by statute. So in exam, the question can be, is this offence summary only? Check the statute creating the offence. If it applies summary only, the procedural consequences follow automatically. So the next thing is starting proceeding. Two pathways, how summary prosecution actually commence. There are two pathways and we need to understand both. The first pathway is charging at police station. After arrest and investigation, the custody officer formally charges the defendant. The defendant is then either bailed or remanded to appear at the magistrate court. The traditional method is still used, particularly where the defendant is in custody. Second pathway, increasingly common for summary matters, is the written charge and requisition. This is a purely postal procedure. The prosecution sends formal document to the defendant's last known address via first-class post. The written charge is the formal accusation. It must describe the fact and essential element in ordinary language, and the defendant can understand, the language defendant can understand. This is not about legal technicalities. It's about clear communication of what is alleged. So the criminal procedure rules, specifically rule 7.3, sets out exactly what content is required. The charge must identify the offense, when it occurred, where it occurred, and the essential factual elements. So in exam, it can ask, was the defendant properly served? Look for whether service complied with the rule 7.3 requirement. Defective service can undermine the entire proceedings. 6-month time limit, and that's what we need to keep in mind. So we reach one of the most critical rule for summary offense, the 6-month time limit. This is an absolute barrier with serious consequences. First, prosecution must commence within 6 months of the offense date. Commence means laying the information or issuing the written charge and requisition. Second, the 6-month period runs from when the offense was allegedly committed, not from when it was discovered, reported, or investigated. Third, courts have no discretion to extend this time limit. Unlike some procedural time limits that can be relaxed, this one is rigid. Fourth, if proceedings start outside the 6-month window, there is usually they are invalid and must be dismissed. The prosecution cannot simply start again. The time bar is permanent. Fifth, always check dates first when reviewing a summary case. This should be your initial analysis. Calculate from the offense date to the charge or requisition date. So in exam, they can ask, is the case out of time? So you need to calculate it systematically by understanding the rule and applying your calculations. So let's shift perspective and consider what defense counsel should do immediately after a client is charged with summary offenses. First, meet your client promptly. Time is critical. In criminal cases, memories fade, witnesses become unavailable, and evidence degrades. Early action protects your client interest. Second, take a proof of evidence from your client. This is a detailed written account of their version of event. You need their narrative, their relocation of their recollection of dates and times, names of witnesses, and any other relevant information. So everything you need to take from your client. Third, obtain their proof, and their memory is very fresh at that time. The closer to the alleged offense date, the more reliable and detailed the account will be. So delay prejudices the defense at that point. Fourth, use this conference to identify potential legal defenses and possible mitigation. Are there defenses like self-defense, necessity, or duress? Even if no defense exists, what mitigation can you advance for sentencing? So at that point, fifth task that you need to do is plan further inquiries based on what your client tells you. Do you need to visit the scene, trace witnesses, obtain CCTV, commission expert reports? The official, initial conference shapes your entire defense strategy. In exam, they can ask, what must you obtain from your client? So keep in mind this slide, and this will guide your answer. So the next thing is proof of evidence, and how it works. Let's explore the proof of evidence in more detail because it's fundamental to defense work. First, it's your client's account in writing. You are recording what they tell you about the alleged offense, the circumstances, and relevant background. Second, it's a working document that evolves over time as you obtain further information on your client's, recall of evidence, and they give you additional information. You update the proof. It's not static. It develops over time, and it progresses with the case. Third, and crucially, it's not disclosable to the prosecution. The proof of evidence is protected by legal professional privilege. The prosecution has no right to see it, and you must not provide it even if requested. Fourth, this privilege exists precisely to ensure your client is free to speak with you, and their words will not be used against them. Client can give you full, frank instruction without worrying about prosecution access and everything. So fifth, the proof enables you to give proper advice on plea strategy. You can assess the strength of the prosecution case against your client's account, identify weaknesses in either side's evidence, and advise whether to plead guilty or contest the matter. In exam, they can ask you, can the prosecution demand the proof? So at that point, the answer is no, a big no. So disclosure, IDPC in summary cases, disclosure obligation in summary cases are governed by the Criminal Procedure Rules Part 8 and the cornerstone in the initial detail of prosecution case is very important, that is called IDPC. The prosecution must serve IDPC in the summary cases before the first hearing. This requirement is universal. It applies whether the defendant is expected to plead guilty or not guilty. However, the content varies depending on anticipated plea. If the prosecution expects a guilty plea, IDPC can be minimal, perhaps just the facts and the defendant's previous convictions. There is no need for extensive detail about unused material. If non-guilty plea is anticipated, IDPC must be more comprehensive and should include the summary of the digitally captured case. This is typically the key evidence, witness statement, the defendant's police interview, and significant exhibits, everything in it. After IDPC, further used evidence the prosecution intend to rely on at trial must be served in accordance with court directions. So unused material is disclosed if it meets the Criminal Procedure and Investigation Act test, material that might reasonably be considered capable of undermining the prosecution case or assisting the defense case. Just keep this line in mind, and I wish you all the best. Hopefully you will secure some marks. In exam, they can ask what changes: disclosure content, guilty versus non-guilty anticipated plea, and what undisclosed document, unused material, they need to disclose it to defense at that point. These are 2 points on this slide you need to keep in mind. So let's examine the Criminal Procedure and Investigation Act 1996 CPIA and how it applies in magistrate court summary cases. First, the prosecution must disclose unused material that meets the statutory test we talked about. They review everything they have and disclose what might undermine their case or assist the defense. Second, in magistrate court cases, serving a defense statement is usually optional. Unlike Crown Court proceeding, like at that point where it is mandatory, so summary cases don't automatically require defense statement. The defense can choose whether to serve one or not. Third, if defense want to rely on witnesses at trial, they must give notice within 14 days of the non-guilty plea. This witness notice requirement is mandatory. Failure to comply can result in witnesses being excluded. Fourth, if defense decides to serve a defense statement, the time limit is 14 days from the prosecution's initial disclosure. This voluntary step can trigger further prosecution disclosure obligations. Fifth, there are tactical pros and cons to serving a defense statement. The advantages, one of the advantage is forcing further disclosure under Section 8. The disadvantages, one of the disadvantage I would say, is revealing your defense strategy early and creating potential adverse inferences if you later depart from what you have stated in that case. So in exam they can ask, is a defense statement compulsory here in summary trials? So you got the answer on this slide. So Section 8 of CPIA provides a mechanism for the defense to force further disclosure when they believe the prosecution is holding material that should be disclosed. However, this mechanism has preconditions. First, you can only use Section 8 after serving a defense statement. If you haven't served a defense statement, Section 8 is unavailable. This is one reason why defense counsel might choose to serve a defense statement even in front of magistrate court. Second, you must show the court reasonable cause to believe that specific material exists. You can't make vague speculative application. You need to identify with particularly very clear terms. Third, you must demonstrate that this material meets the disclosure test, that it might reasonably undermine the prosecution case or assist the defense. Fourth, if these conditions are satisfied, the court can order the prosecution to disclose the material. The court becomes the enforcement mechanism. Fifth, if there is persistent failure to disclose material that should have been disclosed, consider applying to stay the proceeding for abuse of process. Serious disclosure breaches can render a trial unfair. So that's all what you need to keep in mind. So in exam, they can ask, when can you use Section 8? So you should keep all these conditions in mind before triggering Section 8 of CPIA. So first hearing, plea, sentence, or directions. The first hearing in a summary case is critical because it often undermines the entire trajectory. First, the court expects a plea at the first hearing. This is not just a formality. The system is designed for early resolution. That's why IDPC must be served beforehand. Second, IDPC enables the defendant and their counsels to make an informed plea decision. You can't advise on plea without knowing what evidence the prosecution has, so IDPC provides sufficient information for this purpose. Third, if the defendant pleads guilty, the court proceeds to sentence immediately if appropriate, or adjourn for pre-sentence report if the offense is serious enough or if the defendant's circumstances require assessment at that point. Fourth, if defendant pleads non-guilty, the court gives case management direction and lists the case for trial. These directions create a timetable for serving evidence, agreeing facts, and preparing for an effective trial. Fifth, after a non-guilty plea, the parties must complete the preparation for effective trial form, that is called PET. This document captures what's agreed, what's disputed, witness requirement, and time estimate. In exam, they can ask, what happens immediately after a non-guilty plea? So directions are given, a trial date is fixed, and the PET form is completed. So you ensure that you understand all these steps. So the next thing is effective case management, and that's essential for ensuring trials are efficient and the court time is not wasted. Let's identify what court needs from the parties. First, identify real issues in dispute. Often certain facts are not genuinely contested. Isolate what's actually in dispute. Perhaps the defendant, defendant admits being present but denies the act, or admit the act but denies the unnecessary mental element, raises some defense on it. Second, agree admissions and evidence where possible. Section 10 of Criminal Justice Act 1967 allows formal admission of facts. So these admissions avoid the need for witnesses to prove uncontested matters, saving time and cost. Third, confirm which witness must attend and their availability. Not every witness statement requires live testimony. Court distinguish between witness whose evidence is genuinely challenged and those whose statement can be read. Fourth, where possible, agree the content of the defendant's police interview. If there is no dispute about what was said in interview, the recording or transcript can be agreed rather than played in full. Fifth, estimate trial length realistically. Be honest about how long cross-examination will take, how many witnesses will give evidence, and whether legal arguments, is anticipated or not. In exam, they can ask what must be agreed for the effective trial. So you need to understand this slide. So the next thing is contested summary trial. And let's talk about skeleton. So first, the prosecution opens their case. The prosecutor outlines what they intend to prove and introduce the evidence they will call. Second, prosecution witnesses give evidence. Each witness either reads their statement or gives evidence in chief, covering the matter in their witness statement. So third, the defense cross-examines each prosecution witness in turn. This is your opportunity to challenge their account, test their credibility, and highlight inconsistencies or weakness. Fourth, after prosecution closes its case, the defense may submit there is no case to answer. This submission argues the prosecution has not established a case on the face of on one or more element of the offense it is not established. If successful, the defendant is acquitted without presenting any defense evidence. Fifth, if no case submission fails or is not made, the defense presents its case. The defendant may give evidence and the defense may call witnesses. The defense then makes a closing speech. Finally, the magistrate retire, consider the evidence, and deliver their verdict at that point. If the defendant is convicted, the case proceeds to mitigation and sentencing. If acquitted, the defendant is free to leave. So in exam, they can ask, where does no case to answer fit procedurally? So after the prosecution case closes and before the defense case begins. That's what we need to keep in mind. Now let's go to either way offenses. Why venue matters. So first, either way offenses occupy the middle ranking of seriousness. They are more serious than summary only offenses, but less serious than indictable only offenses. Second, the factual circumstances can range enormously. Theft, for example, could involve stealing a chocolate bar worth £1 or stealing a car worth £40,000. Both are theft under Section 1 of the Theft Act 1968, but the gravity differs vastly. Third, preparation for either way offences mirrors summary cases up to a point. You take instructions, obtain evidence, and prepare your defense case theory, so the disclosure regime is similar initially. Fourth, the first appearance is always in the magistrate court, even though the case might ultimately be tried in Crown Court. This initial hearing determines what happens next. Fifth, the plea before venue procedure triggers the allocation process. This is where either way offences diverge from summary only offences procedurally. So in exam they can ask, is this offense either way and why? At that point, classification comes from statute creating the offense. So at that point, Section 1 of the Theft Act, for example, specifies theft is triable either way. So let's talk about plea before venue, the difference between either way and summary only offenses. The venue decision process for either way offences involve distinct stages that must occur in sequence. So let's talk about them. First, plea before venue occurs. The defendant indicates whether they would plead guilty or non-guilty if the matter proceeds to trial. This is an indication, not a formal plea yet. Second, if the defendant indicates guilty, the magistrate accepts jurisdiction for sentencing or commit the defendant to the Crown Court for sentencing if their powers are insufficient. There is no allocation hearing because the defendant has indicated guilty. So third, if the defendant indicates non-guilty, the allocation hearing follows. This is where venue is determined. Fourth, at allocation, the magistrate decides suitability first. They consider the case seriousness, complexity, and whether their sentencing powers are adequate. They apply the sentencing council's allocation guidelines. Fifth, the magistrate accepts jurisdiction. The defendant then has a choice. What's called election? So that's called election. The defendant can contest to summary trial in the magistrate court or elect Crown Court trial with a jury. Sixth, if the magistrate declines jurisdiction, the case goes to Crown Court regardless of what the defendant wants at that point. The magistrate decision trumps the defendant's preference in that scenario. So this slide is a must. You just understand that how this election works between summary trial or committing it to Crown Court. Our favorite, sorry, the text or the font is very small because we had to fit in load of things on in here. So tips and pitfalls. First, always classify the offense before advising on anything else. It is summary only or either way. Classification determine which procedural track applies. Second, for summary offenses, check the 6-month time limit immediately. Calculate from offense date to charge or accusation. This is often the first issue in exam questions. So third, remember Rule 7.3 of criminal procedure. For charging, the charge must be clear in ordinary language and identify essential element. Defective charging can be challenged. Fourth, in summary cases, IDPC is always required before first hearing. This is not optional. This is mandatory disclosure obligation regardless of anticipated plea. Fifth, the defense statement are optional in magistrate court cases. Don't confuse this with Crown Court proceeding where they are mandatory. So, sixth, Section 8 CPIA application for further disclosure only work after serving a defense statement. You can't use Section 8 without first serving a defense statement. Seventh, for either way offenses, don't merge the BBV, plea before venue, and allegation stages. They are sequential. So PBV, plea before venue first, and allocation if not guilty is then allocation if not guilty is indicated. Sorry. So once again, seventh, for either way offenses, don't merge the plea before venue and allocation stages. They are sequential. PBV first, then allocation if non-guilty is indicated. Another thing, 8 at allocation, remember the decision sequence. Magistrate decides venue suitability first, then if they accept jurisdiction, the defendant may elect Crown Court trial. So if magistrate don't accept, it will go to Crown Court. I hope this helps you. If it does, subscribe to our channel and share this with your friends. I wish you all the best. Ta-ra.